A Charlotte Mecklenburg teacher is facing charges for having sexual relations with an 18-year-old student at South Mecklenburg High School. Detectives arrested 26-year-old Gabriella Neufeld yesterday. She bonded out of jail a little after 3 o'clock this morning. The first instance of the crime dates back to last month.
And CMPD officers announcing this arrest earlier this morning. Chief Legal Analyst Khalif Rhodes is here to talk to us about the case. Of course, details just coming in. But what stands out about the charges that this teacher is facing?
Most folks aren't aware of this type of charge. This is something that was implemented by our General Assembly. And I'm intimately aware with this because I've represented individuals charged with this type of charge. It's a power dynamic type of charge. It's not a statutory rape of thing because this individual was over 18. And so you would assume two 18-year-olds, they're consenting, they can engage in sexual relations. Well, no, the General Assembly wants to stop that from occurring. And so if a person is in a position of power, a teacher, a school administrator, someone, they don't even have to have been that student's teacher, and that student is in the same exact school, that falls within the statute, and this would be a charge of engaging in sexual activity with the student, and that's what the teacher's charged with.
How do you even go about defending someone that allegedly has put themselves in a position of authority and care, supposed to be taking care of students no matter what age, and they cross this line allegedly? How do you defend
A lot
that?
of times when I have conversations with clients, it's about level setting from the very beginning and letting them know what the expectations are so they don't have unrealistic expectations. Oftentimes, folks may think if they're charged with trafficking, for instance, I don't want to go to prison. Well, there will be some prison time. We're attempting to mitigate what prison looks like if they have you dead to rights. In a charge like this where consent is not a defense, you can't say we consented so I can defend to that. Typically, I'm trying to avoid prison time, and some active conviction of a felony may be pled down to a lesser charge, and explaining to them what the process would look like. And so managing expectations and managing and mitigating what the long-range punishment would normally be what legal services would look like, unless it was an identity thing. Because remember, you also have to be that teacher. Well, what if there's text message or an allegation that you did this, and you're like, hey, it wasn't me. I didn't do this. I'm not that person. That would be where I would start, obviously. But if there's pictures, if there's text messages, if there's video, if they caught you in the act, it's not really, I won't say defensible, but the strategy changes.
We do know that teacher has an initial appearance at 1:30 this afternoon. What will happen
That's
there?
just her, she's already bonded out, and so this would be her bond hearing, but since she's already posted her $75,000 bond, she'll appear, they'll set a new court date, they'll address counsel, and so they will either assign her a public defender or ask her what she wants to do in terms of representation going forward. After that, she'll have something called a probable cause hearing, and that's where they'll determine if the state actually had probable cause to charge her with the charge. And in between that time, she'll look to find an attorney or talk with her public defender.
The nature of crimes like this, always concerning for parents. You've got 4 girls. When you hear that it's happened in schools.
I've got 3 of them, so
Yeah.
I'm all over this in terms of making sure that students are safe, and making sure that they're protected from folks that are supposed to be protecting them. And so this is what the General Assembly is attempting to protect and ensure that these types of things don't happen. Again, most folks are thinking, well, hey, they're 18. This is not something that we needed to protect. But in the Me Too era, where people are in positions of power and they take advantage of their positions of power, a student is still a person that's vulnerable, even if they may be the same age or close to age. That's why that 4-year gap is what's in the statute. And so
We're having more and more of these stories that we report every couple months in states and schools around the country. I wonder if it would be helpful for the administration, the principals, the superintendents, to remind the teachers and faculty every so often, hey, don't forget, don't put yourself in a position where you're alone with a student, because a lot of students approach teachers because they have problems at home. They want a shoulder to cry on, and then things slowly cross the line. Don't you think that would be helpful, though, if administrators from the top down remind their faculty, hey, don't put yourself in a position. I know we talked about it last month. Don't go there. Your job's in jeopardy, and it could lead to legal issues.
A couple things I'll say quickly. My family's a teaching family. My sister's a teacher. My mother-in-law's a principal. My brother's a teacher. So I come from a teaching family. And so they talk about those things in the house all the time. What I can say is it starts at home, recognizing that you don't want to put yourself there. But also the lines are blurring where you want accessibility to teachers. You want them to be on social media. Well, students are on social media. So if they're there and they're very close to age, like you're 18, you're 22, you just graduated college, these 18-year-olds that are about to go to college, those ages are so close. And so ensuring that you don't even attempt to get close is a very hard line to walk close to, because you want to engage your students, but you don't want to engage like this.
Chief Legal Analyst Khalif Rhodes, thank you for your insight on this.